Hi, my name is Marina Berhovich, and I'm the CEO and founder of YourCoach. In the world of health coaching, we're always working to help our clients become their best selves, while striving to become our best selves along the way. That is why I'm so passionate about health coaching, and that is why my team and I work tirelessly to bring you the best experience possible. Receiving my coaching certification not only inspired me to launch YourCoach, but it helped me become a better version of myself in more ways than I could have ever imagined. That is something I truly needed as I was healing my body and soul throughout my cancer journey. The driving force for me and my team is creating a virtual home for all things health and wellness coaching. For you coaches, we're giving you a home to manage your practice and help your clients become their best versions all in one place. And now we're taking our promises a step further. We now provide additional opportunities for our active coaching community through our employer partnerships. For you progressive employers and leaders, we're matching your hardworking talent with health coaches based on their individual needs and unique health goals. Especially now as work and home lines are being blurred, and if you care more about health and not just healthcare as most of us do, it's time to start investing in what goes on beyond the doctor's office. And that's not all. We're not stopping here. In order to motivate the coaches on our platform to continue developing their skills and to bring the power of health coaching to more people than ever, we're so excited to introduce a revolutionary gamified pricing model that's going to turn the practice management industry on its head. Now, for practicing coaches on our platform, it's possible to bring the cost of the platform down to just $10 a month with unlimited clients and full platform capabilities. We recognize that becoming our best selves is a journey, and we're so grateful to have you on this journey with us. We're confident that through our best version, we can ensure that anyone who wants or needs access to a health coach will have one. Because at the end of the day, we all just want to be happy and healthy humans. Join us on the health coaching revolution.
I'm Barbara Zabawa, and I'm glad that you're here. I don't know how many of you are out there. But we are going to talk about contract law today and answer any of your questions on that topic. And thanks to YourCoach for putting this together. I guess a little bit about me is I'm a lawyer. I operate and own the Center for Health and Wellness Law. And we're located in Wisconsin, but we serve clients all over the U.S. A lot of health coach clients from all over the U.S. actually. And one of the big things that we help them with is their contracts, their agreements with both their clients, because you should have client-based agreements, as well as with contracts between the coach and if they, for example, want to work for an organization as an independent contractor. Maybe they want to do corporate wellness, corporate health coaching, and they need an agreement between them and the company that hires them to come into the workplace, for example, and do coaching. So there's those types of agreements too, those are the typical ones that we help coaches with. And then of course, if they're going to be an employee, we can review any employment agreement, or if they want to hire employees or independent contractors or other vendors, we can draft or review those. So contracts are everywhere, and it's really important to understand what is a contract exactly, what makes it legal, and you know, what are some good things to look for in agreements. So I'm not going to probably go through everything that's in these slides just because of time, and I know that you all have some questions. There were some that were submitted in advance, and so I know that I'll have to address those, and then any others that you guys might think of. So hopefully that gives you a little bit of background about me and my firm. You know, we specialize in wellness law, health and wellness law. So in addition to coaches, you know, we also represent licensed providers. We represent sometimes insurance companies, sometimes bigger health clinics. We do work, not with just contracts, but, we do work with compliance with federal and state laws. We do work with, like, if you want to sell supplements or other types of wellness products. I've helped with some intellectual property issues, which these slides also have some intellectual property information, but I don't think we're going to have time to talk about that today. So things like trademarks and copyright and, patents, probably not, although I've done my own patents for my own businesses. So yeah, we telehealth kinds of advice. We have all kinds of expertise in different areas involving health and wellness. We try to be a full service law firm for people working in the health and wellness space. So pretty much everything except litigation. We don't bring lawsuits. That's one thing that we don't do. We try to prevent lawsuits. I like prevention more than reaction. So getting to our slide deck. If you are coming into an agreement with someone, whether it's verbal or written, there's going to be laws that kind of govern that agreement. So that's why we have contract law. And contract law, unlike some areas of law, really spans across not just in the statute or rule books, but also in court cases. So we call that the common law. So court cases sometimes provide the guidance that you're looking for as to whether there's a valid contract or whether there's a violation of a contract. So contract law makes it a little bit more difficult for people to really know what their rights are, because you can't just look up in a statute or rule book. You have to also look at court cases, and that can get really tough. But that's why we have lawyers, and that's why we go to law school, is to learn how to navigate the different sources of law and how to weigh their importance and evaluate specific fact patterns against those different benchmarks. And so that is something to keep in mind, if you're looking to do it yourself, which I know a lot of people, especially if they're starting out with a coaching practice, they're looking, for ways to save money. I'm all about that. I know that, I have my own businesses myself, so I understand that need to kind of minimize costs, but there's some things that, you just can't avoid. It's just part of doing business. And law is not something to be taken lightly. So just keep that in mind as you are, navigating your own coaching practice. Okay, so in order to have a valid contract, no matter what kind of contract we're talking about, for coaches, whether it's between you and your client or you and a company, there's certain elements that need to exist for it to be valid. If you don't have these elements, it's not going to be a valid contract, even if it's in writing. So contracts, can be, again, verbal or in writing. Some contracts have to be in writing, and that will be dictated usually by state law. But not every contract has to be in written form. You can have a verbal agreement and it can be enforceable. And if you break that agreement, or someone else breaks that agreement, you can bring a lawsuit for breach of contract, even if it's not in writing. Now, if it's not in writing, it's harder to prove that it was broken or what the agreement said. because there's nothing to reference. It's basically, you know, your word against the other party's word about what you guys agreed to. So that's why it's always good to have it in writing. But that doesn't mean that it's not an enforceable contract unless it's one of those specific types of agreements that needs to be in writing according to your state law. And usually the agreements that absolutely need to be in writing usually are agreements for the purchase of real estate, or agreements that for services, for example, that are going to take more than a year to complete. Those are two examples of typical agreements that must be in writing to be valid. But otherwise, the elements that you need to have a valid contract are an agreement. So something that you're going to give, that the other person's going to take. And in addition to that agreement, consideration. So there's something of value that's exchanged between you. It could be money. So, and oftentimes that is the consideration, is money. So you agree to provide services to a client in exchange for them paying you your rate. That's consideration. Contractual capacity is another element that really is getting to, do both parties who are making the agreement, are they competent, you know, and are they in the age of majority? So minors under 18 can't make a contract. They're not legally, they don't have the contractual capacity to do so. So a parent has to step in. Or if you are, you know, deemed incompetent, maybe because of some, you know, disability or cognitive disability, or because maybe you are incapacitated somehow, maybe because of substance use or something that's affecting your judgment. If you are in that kind of state of mind, you're not going to have the contractual capacity to enter into an agreement. And if you do, and that agreement will not probably be valid. So if you are, you know, seeing clients who look like, you know, they're not in the right frame of mind to make an agreement, you know, maybe they're just overwhelmed with emotion, something horrible just happened and they're not in the right state of mind, and you try to have them enter into agreement and an agreement anyway, they could come back and say, you know what, I really wasn't in the right frame of mind, and so there really isn't an agreement here. So you want to make sure that whoever you're entering into agreement with is capable of doing so. They're clear-headed, you know, they're at least 18 years old. They're not under the influence of any sort of substances or overwhelmed with emotion. You just want to make sure that they're in a good place, so that you don't come back later and find out that they never really agreed to the agreement because they weren't in the right frame of mind. And then legality, your contract has to be for legal services and products. You can't agree to something that's illegal. You can't agree to something that's a crime, for example, you know, an agreement to hire someone to, you know, murder another person. That's an illegal contract, even though you may have exchange of money, you know, you're both on the same page as far as what the agreement is, you're both clear-headed. The underlying subject of the agreement is an illegal act, and so that would not make the contract legal and it would be invalid. Okay. So when you have an agreement, somebody makes an offer, it's like, I will give you these services. And usually your agreement will say, here's what the terms of my services are. You know, I will my services during this time of day or on these days for this length of time. And these are the kinds of things of services I'll be providing. Those are the terms of the offer. And then the person who you're offering them to will have, can agree to those terms, or they could ask maybe for you to revise those terms. Maybe I only want these services, not the whole list, but just these, or maybe I want those services during these days and not those days. And are you willing to amend your agreement? A lot of times people will wonder if certain advertisements constitute agreements, like you're promoting something on your website, and is that basically an offer and that people can accept, and then does that create a binding agreement? And that will depend on how it's worded. Obviously, that's a business decision too. Like if you're offering, buy one, get one on your website or whatever, and then you don't honor that, that could lead to false advertising. So you want to make sure that whatever you are offering is you stay true to it. But there can be instances where you're trying to gain attention, and maybe as part of your advertisement, you're implying that, something great will happen. And people are wondering, well, is that a promise? Are you making a promise? And is that something that you have to keep? And there are court cases. This is where court cases come into play that have sort of defined what constitutes an actual offer versus an ad that's just being used for entertainment kind of value. And so when I teach contracts to my students at UW-Milwaukee, one of the things that I go over with them is this Pepsi commercial that's from the 1990s, where Pepsi had Pepsi points, and there was a commercial that showed what you could get for whatever types of points you would earn by drinking Pepsi. So you could get jackets and t-shirts and sunglasses. And then at the end of the commercial, the young teenager who was the focus of the commercial, you see him landing a fighter jet at school, and it says Pepsi points, like 7.5 million Pepsi points will get you this F-16. And some guy out in the state of Washington took that as a valid offer, and he collected that many points and submitted it to Pepsi saying, okay, give me my jet. I want my jet. And Pepsi said, no, that was not really an offer. And they went to court, and the court sided with Pepsi and said, that most people would not view that as a, valid offer. That was just something that was used for entertainment value. And, unfortunately, this person did not get the joke, essentially. So that's always an interesting case to study about things that you have to look out for when you're advertising. And let's see. Okay, so once you have an offer out there, then somebody has to accept your offer. And there are all kinds of case law materials about when is an offer accepted, especially in the days of, when you actually had to mail, with snail mail, your offer or your acceptance of the offer. When did that actually take effect? As soon as you put your acceptance in the mailbox, or when the person who made the offer received your acceptance? And there's this thing called the mailbox rule, that once it's in the mailbox, it's done. You've accepted the offer. It doesn't matter if the person who's offered you the agreement hasn't received your acceptance yet. It's in the mailbox, and so it's been accepted. Okay, so consideration, that's the other element of a valid contract. As I said, most of the time it's money, but it doesn't have to be. It can be, a service for a service, or, like the barter system. It can be all kinds of different things, as long as, it's reasonable. That's consideration. And this rest of the slides talking about promissory estoppel. That's when there's an enforcement action about a breach of contract, and I don't want to get into litigation of contracts right now, but there are all these legal theories about when a contract has been breached, if what kind of remedies are available, what kind of causes of action are available. Okay. I talked about contractual capacity. Remember, if the person who is making the agreement with you, they have to be of sound mental mind. They can't be intoxicated. They can't be a minor. Otherwise, the contract is not valid. And then legality, again, the subject of the contract has to be a legal purpose. You can't contract to do an illegal act. So genuineness of assent. This is important too. So when you are, as a coach, giving your clients a chance to agree to your services agreement, for example, it's really important to make sure that they understand what the agreement says. And so if you're giving it to them and not giving them enough time to really ask questions, review it, then if they sign it without having the benefit of that time to really review everything and ask all the questions they may have, they could come back and say that the agreement is invalid, because even though they may have signed it, it was under duress. They were felt under pressure. So that's why when you start a new client relationship and you give them an agreement, give them an opportunity, as long as they want, to review it, to ask questions. If it's something you can do well in advance of your meeting so that there's no time pressure, that would be better, because if you force them to sign right away, like on the first day that they see you for their first appointment, before you start working with them, they may feel like they didn't have enough time to review it, everything, and they could come back later and say, I never really agreed to that because I didn't have enough time to really look at this agreement. So it's really important to make sure you leave enough breathing room with your agreement and to have them before they sign it, just so you can't be accused later of forcing them to sign under pressure. So unconscionable contracts or clauses. Sometimes, people try to get others to agree to things that just are not reasonable. And for whatever reason, they do agree to it, but, in hindsight, it's a really awful contract for them. And they may be able to say, you know what, that agreement is unconscionable, and that means it was unfair. And so a court could basically say that the contract wasn't valid because of that. So you don't want to write agreements that are so heavy-handed or draconian that the other side is going to be able to say it at some point when you're trying to enforce that agreement against them, that, you know what, that agreement really wasn't fair and I'm going to sue because it's unconscionable. So you want to make sure whatever agreement you do have drafted, that it's fair, that the terms are fair. Otherwise, it could come back to bite you. The statute of frauds, I alluded to that earlier when I said there are some agreements that must be in writing in accordance with state law, and that's in accordance with the statute of frauds for the state. So the statute of frauds is what dictates what types of agreements need to be in writing versus those that could be verbal and still be enforceable. So some examples again are interests involving land or real estate, contracts that take at least a year to perform, marriage, some marriage agreements have to be in writing, and some sales of products, physical goods that are priced at $500 or more. So really expensive items like cars, need to be in writing. Can't have, an enforceable contract, verbal agreement for goods that are really expensive. Now, there may be carve-outs with that again, and that's going to be state by state. So that's something you're going to want to look at. If you find yourself selling goods, for example, you're going to want to review your state's laws on determining what some exceptions are for maybe higher priced items. I'm thinking of, private parties that sell cars for more than $500 all the time. And do they have a written contract? No. So you just want to review your state's laws to make sure that you're covered. And this slide saying the same thing about the statute of frauds. So, a lot of agreements will have warranties or disclaimer of warranties. They don't want to make any promises that you're going to achieve these results. So you want to make sure that, you're clear in your contract that you're not like if you're coaching on diet and nutrition, you don't want to make any promises that, and if you go with me, I guarantee that you're going to lose 20 pounds. I think that's dangerous. I don't think you want to have that kind of responsibility, because if you don't do it, then they could sue you for breach of contract. So you want to have disclaimers of warranties and guarantees in your contract, so that people do not expect certain results when they see you. So a contract ends once the the terms of the agreement have been satisfied. And there's an inherent expectation in every agreement, even if it's not written out, that the performance is, if it's a service, for example, you're doing a coaching service, that the performance is going to be satisfactory. That if there's an implied good faith and fair dealing element to every contract, that you're going to be fair, you're going to do your best work, even if that, again, that's not written, that's an expectation in every contract. Now, if there is a breach of contract, of course, there's damages that the person who is the victim of the breach, I guess, can seek. They can seek financial damages, what they paid for the services, if they weren't happy with the services, and any other damages that might have incurred, monetary damages. So usually the contract is limited to like financial kinds of damages. Or if you didn't perform the work to their satisfaction, they could ask a court to, force you to perform to their satisfaction. So there's all just kinds of different damages and remedies that people can seek. A lot of times contracts will limit those remedies, though. And a lot of the agreements we write for our coaches, you know, we limit the damages or the remedies to what was paid under the agreement, nothing more, nothing more. So that's something to consider, so that you aren't on the hook for more than, you know, what was paid. So if you're selling goods, and the person isn't happy with the good that you have provided, you know, they may sue to reject the non-conforming goods and ask for, you know, goods that are satisfactory to them. And they also could have damage claims as well, depending on if somebody got hurt. So click-on agreements, that's what I see a lot of with coaches is, you know, they have their services agreement as part of their portal that they use. And so they are asking people to, you know, read through it and then click to sign. And those are fine. You can do that. In fact, you know, allowing people to read at their own pace, you know, when they're ready, when they have, you know, time available to look through your agreement, that can be a good thing, as opposed to having them, if you're doing an in-person consult, you know, having them read the agreement while you're sitting there might not be the best, because then they may feel pressured to sign. Oh, sorry, where did my thing go? Okay. So click-on agreements are okay. You can do those. And that was allowed really through the Uniform Electronic Transaction Act, where e-signatures were permitted. So that's something you want to consider. Now, what time is it? I want to make sure I have enough time to answer your questions. So I just want to see. Oh, this is the intellectual property. So that's my presentation essentially for the contracting. Again, I don't want to cover the intellectual property. We can do that again in another session. So with that, let me see what. So first question that came in advance is, do you recommend using templates for client contracts? And if so, where can I find them? That's a great question. Templates can be useful. I won't kid you. And they're not going to be free. And at least any of the good ones are not going to be free. So, you know, if you can pay for the template and try to do it yourself, or you can pay for someone like our firm to help you with drafting your agreements. But either way, it's probably not going to be free. But templates can be a good way to start. And I know that YourCoach is considering working with my law firm to provide templates, but we haven't, that's something for the future. So for now, you know, they can be found, you can go to libraries. There are services that you can pay for that have like archives of templates. As a lawyer, you know, we have resources that we pay for to get templates. They're kind of pricey, those services. And I'm not sure you can get them as a non-lawyer. But templates can have a good start, you know, and you could probably Google and maybe find some templates. But the problem is, again, not knowing what you don't know, if that makes sense. I mean, are you trained to write contracts? I've seen some really awful contracts that were clearly written by someone who was not trained to write a contract. You can tell it's pretty awful. And if it's that awful of a contract, it's probably not going to even be helpful because there's probably a lot of things wrong with it. So, you know, you can try to use a template, but again, what is it that you aren't covering that you should be covering? What is it that's in the template that isn't there that maybe would be good for you? Or what's in the template that is there that maybe doesn't really apply to you, but you don't know it doesn't really apply to you? That's the problem with using templates. It's just you don't have any guidance. You're making your own judgment calls, and on what are you basing that judgment? Did you take a contract course? Do you know what you're looking for, or what you're not? And that's why people go to law school and get trained on these things, is to know what to look for, to know what's not good, to know what is good. Just like coaching, you get certified in coaching, so you know what to say and what not to say, and what's a good idea and what's not a good idea. The same thing can be done with the law. So just keep that in mind. I mean, certainly you're welcome to use templates, but if you have no idea what you're looking at, that might be a sign that maybe you should get someone who does know what they're looking at. Second question, I don't have a contract, but I already have clients. Can I send them a contract halfway through their program? Yes. I mean, you can say your consideration or your agreement can be continuing the program requires us to enter this into this agreement. At the beginning of a client relationship, the agreement is, before I start providing services, we need to enter into this agreement. But if you're halfway through, what you can do is say, well, to continue our services, even though we've already started, to finish our program, we need to enter into this agreement. That's probably the way I would approach it. What should I include in my contract if I work with different clients from different states? There are some things, contracts, yes, is a state-by-state thing, but there are some uniform provisions that can apply to all states. So, things like, obviously, the services you provide and how much you charge for those services, that can apply to all 50 states. Things that you might run into problems with are things like disclaimers and waivers of liability that might change from state to state, what's allowed. And that, again, is probably going to be more found in case law. And then if you're selling goods as part of your coaching agreement, that might change from state to state on what, the expectations are for that. And, where you want to have disputes. If there is a dispute about your agreement, that probably can stay the same through all 50 states. But so I would say most provisions in these service agreements probably can stay the same throughout all 50 states. It's just, if you're getting into employment agreements, those things will probably have to change from state to state. Certain common provisions in employment agreements, like non-compete agreements or non-solicitation agreements, that stuff, states are vary on how they regulate those kinds of provisions. But for most parts, client service agreements, I would say most provisions can apply. There just may be some tweaks you need to make on a state-by-state basis with your waivers of liability and things like that. Where do I get the latest information on what I can and can't do in my state? And I don't know if this is related to a contract. When I read this earlier this morning, I think what they're asking is about scope of practice as a coach. What can you do from state to state as a coach? And that the latest information, I mean, you can subscribe to my law firm's newsletter, but they're really, I mean, for nutrition, there is a resource out there for nutritional advice that does 50 state analysis. But for the most part, if you're looking for more of the detail on what you can and can't do as a coach by state, it really is going into the various states licensing statutes and regulations and reviewing the practice of medicine, reviewing the practice of dietetics, reviewing the practice of psychology, as the most typical ones that you're going to want to know what those individuals who have those types of licenses can do. And that will kind of inform you on what you shouldn't be doing as a coach without one of those licenses. And that's just kind of, and unfortunately, those licensure statutes don't change a whole lot from year to year. They're pretty steady. So that's good. So just familiarizing yourself with the licensure statutes and rules for those types of licensed practices is a good way to stay on top. And of course, it requires you to read regulations and statutes. And again, it depends on your comfort level in reading that kind of language and understanding it. So if you need help, that's again something that we do. If I work with doctor's office who carries the liabilities for my work, and what do I do? What do I need to prepare? So I think the question is, if you're a coach and you're contracting with a physician's office, who carries the liability? Well, that will depend on if you are an independent contractor or if you are an employee. If you're an independent contractor, you probably carry the liability. You should carry the liability for your work. And if you're an employee, they should. And what do I need to prepare? I'm not quite sure what the question is asking there. I'm prepared for what? So that would need more, I would need more details on that. As a functional medicine health coach, I can interpret lab work. Can I do that in my practice or even order lab tests? And that's a great question. I've actually written blog posts on my website about that. And the answer, if you're a coach, you shouldn't be ordering lab tests and you shouldn't be interpreting lab results. That is a risky practice because basically a coach is there to give support and to give education and information. And if you're ordering labs, I'm not quite sure on what legal ground you're ordering the lab, unless these are direct to consumer type labs and you're telling the consumer, your client, to go get this lab, which they can do. And that's going to vary by state. But then if you're interpreting those labs for them, on what grounds are you doing that? On what training are you doing that? Interpreting labs for individuals really is getting into the practice of medicine or some other licensed health profession, because you're identifying potential diseases or illnesses or conditions. And that work is not the work of a typical coach, unless they have a license to do that kind of, but then that's not the practice of coaching. That's really the practice of medicine or nursing or dietetics or some other licensed professions. So that I would be very wary of doing those kinds of things as a coach. And then I can go to the Q&A. Where we have a number of questions. Is it a necessity to have a lawyer review our client contract? If not, but highly recommended, why? Great question, Karen. Karen, you got quite a few questions here, so that's awesome. Do you have to have a lawyer review your client contract? No, there's no law that says you must have a lawyer review your contract, but yes, I would recommend it. And for the reasons I stated earlier, because you don't know what you don't know. Contracts have a lot of different provisions and you may have no idea why a certain provision is in there, what it's doing and what effect it will have if it, has to be enforced. So, that's why you would want a lawyer to review your contract. and or write your contract so that it is as favorable to you as it can be. And that's the problem. I guess I'll go back with the templates. A lot of times the templates that are out there aren't written in a favorable way to you. Maybe they're more client friendly, but you may not know that. Looking at it, you can draft a contract to be more favorable to you than your client and still have it be enforceable and valid and all of that. But you can also, on the flip side, draft a contract to be really favorable to your client, and not so much to you. And so when you download templates, you may not know what kind of contract you're getting. Are you getting one that's really more geared toward siding with the client or geared towards siding with you? And because you can draft it either way, and you want to make sure it's drafted as favorable to you as possible. So that's something to keep in mind. What's the typical fee to have a contract reviewed? Yeah, I mean, it's going to depend on the length of the contract. Contracts can be varied in length. So if it's many, many pages, it's going to take longer. And usually lawyers charge, in the time that they spend. So obviously a longer contract is going to take longer to review than a shorter contract. And so, it's going to depend on, the length and the difficulty. I mean, for us, we see a lot of contracts in this space, so we can look at it a lot more quickly because we have experience. I would say, a couple hours tops is a good estimate to get a contract review. If I am a healthcare professional in a state requiring a physician collaborator, and I'm not physically touching a client, just coaching and consulting with them, must I still get a physician collaborator? Well, it depends on whether you are practicing as an NP, Karen, or if you are practicing as a coach. So, and I think it's really important to keep those two service types separate and not to conflate them, because that gets messy. So you really do want to determine, are you seeing this person virtually as a coach or as a nurse practitioner? If it's the nurse practitioner, then yes, you will need a physician collaborator. If it's as a coach, then you don't need the physician collaborator, because coaches aren't regulated by any state. So, but you need to set those expectations up front clearly, and that should be in your services agreement with your client, so they know that you are seeing them as a coach, not as a nurse practitioner. Even though you have that education, you aren't practicing as an NP in this instance. And a lot of times I have my clients who have those dual roles. They have the license, but they also function as a coach, to have separate businesses or separate websites for those different services, just so there's no confusion between the two. Is my client considered competent if they have subjective or mild cognitive impairment or early Alzheimer's and sign the contract with me? And that's going to be a judgment call. And there are cases, legal cases, where that type of question comes up, and a court has to hear testimony from physicians who specialize in cognitive impairment to determine if the person who, when they signed the contract, were lucid and able to sign. And so, that it's really going to depend on what state you're in, how much impairment was there. Were there any warning signs that you saw that you maybe would have given people pause that maybe I shouldn't be entering into this contract with this person? Maybe they need to have, a guardian or someone else sign on their behalf. So those are the kinds of things you'd want to be asking. Can a client back out of a contract? Do they have 3 days to change their mind, signing mortgage paperwork? I mean, that's a state law thing, whether there's a certain time period that people have to back out of an agreement. So some states require a waiting period, if you will, for certain types of contracts. Some businesses, just as a business practice or business courtesy, decide, even though it may not be legally required, to give their clients or customers a chance to back out as well. That certainly reinforces the presumption then that if they don't back out and they had an opportunity to back out over a certain time period, that they were truly, assenting to the agreement, that they can't come back and argue and saying that they felt pressured or that the agreement was, unfair. They had time to review it, and then they signed it. So there are business reasons, and then sometimes depending on the type of contract, like you mentioned, mortgage paperwork, or that may be dictated by state law, an opportunity for a client to back out after they've signed the agreement. Is there a concern when coaching someone virtually in Europe with a contract suitable for the US? It depends on who's where. So if the coach is in the US and the client is in Europe, there's some information that the client has to have that to know that the person they're working with is in the US. But as the coach in the US working with people from Europe, there may be certain things you need to be aware of, privacy laws being one of them. There may be things that you need in your agreement regarding health information or information you're collecting that has to be compliant with certain privacy expectations of people who are in the EU. And so you'll need to be aware of those kinds of things and ensure that you're in compliance with that. Where did I get? It looks like I got through all the questions. So let's see, there's a chat box. I see there might be some more in the chat. There are. Okay. I hadn't opened the chat, sorry. If I'm healthcare, I got those. Okay, if I'm and I answered, I see, this is a new question. If I'm a licensed NP in one state, can I coach and consult in other states? Yes, you can as a coach, and you have to be careful about how you're advertising yourself in those other states where you don't have a license. And we help clients all the time with, structuring their practice so that they're not misrepresenting their services in states where they don't have the NP license. But at the same time, at least telling people about their education, because that can be a selling point for your coaching business. So it's a tricky area, but certainly we've helped clients navigate that before. All right, so I don't know if there were any other questions.
Yeah.
Okay, let me get to my contact information. If you do have other questions, here's a way to reach out to me, multiple ways to actually reach out to me. So I'm happy to connect with you all on social media. You can sign up for my newsletter through the website. And my phone number and email are also provided. So I hope this was helpful.